I'm trying to look respectable for a
Oh,
change. Okay, so now I think we're recording. Okay, so here we are. Uh, Good afternoon, Vladimir, students and guests. I'd like to talk to you today about certain aspects of the English legal system as they affect commercial law and indeed business law. My talk will cover the following areas. First, judicial interpretation, common law versus legislation. Second, the doctrine of precedent and how it is applied by the courts. Third, some contrasts between common law and continental systems, pertaining particularly to procedure before the courts and the judiciary. Finally, the interplay between common law and equity and how this applies to commercial practice. But first, I would like to deal with a question which frequently occurs in this context regarding international commercial jurisdiction. Namely, where exactly does English law apply? To answer, we need a short geopolitical tour of these islands in order to distinguish between Britain, Great Britain, Northern Ireland, and the Republic of Ireland, and indeed the United Kingdom. Britain consists of all the countries on this island, namely England, Wales, and Scotland, while the UK is Britain plus Northern Ireland. Britain and Great Britain are the same thing. The Republic of Ireland is a sovereign, independent state. From an international jurisdictional perspective, it is important to keep in mind that there is no such thing as United Kingdom law. English law applies only to England and Wales, which is regarded as a single jurisdiction from an international jurisdictional perspective. Scotland is a different jurisdiction for the same purposes as is Northern Ireland. The Republic of Ireland is not part of the United Kingdom and is a separate jurisdiction altogether, with its own laws, constitution, political system, and parliament. Although it is part of the common law countries like Canada or New Zealand or Australia, Irish law does not apply in the UK and vice versa. With common law systems in general, judge-made law rather than codified law is at the heart of the system. Nevertheless, legislation or statutory law, as lawyers call it, is also a very important source, with statutes being interpreted to give effect to the intentions of Parliament as far as possible. If no legislation exists to cover a particular dispute, then case law applies. And if no case law can be found, then customary law, or in the final analysis, business practice can apply. However, this last scenario is highly unlikely in today's complex legal world, where legislation and case law seem to cover every aspect of our lives. Turning back to English case law, it is important to be aware that the doctrine of precedent, called stare decisis in Latin, applies to all cases, including commercial cases that come before the courts of England and Wales. According to this doctrine, the decisions of higher courts in the system bind lower courts, with the Supreme Court, formerly known as the House of Lords, at the apex of this pyramid, providing, however, that the facts in each subsequent or existing case are the same as in the precedent, or substantially the same. So, what happens if a precedent is not favorable to your client's case? i.e., we are faced with what we call an adverse precedent. In that case, lawyers in common law jurisdictions try to distinguish their existing case from the precedent by arguing that the present case is different in some significant factual respect from the previous case, the precedent. This is known as distinguishing on the facts. It is also possible to distinguish on the law by effectively arguing that the precedent itself is legally incorrect. But this is a more difficult and unusual process. Another area where a striking contrast can be seen with continental systems is with regard to procedure before the courts. English, and indeed all common law system procedure, is adversarial rather than inquisitorial, which means that each trial is like a contest or battle between the parties to the litigation. And it is the parties who bear the burden of presenting evidence to the court or to the judge, who decides on the evidence presented only and who does not inquire into factual matters. Unlike continental systems, where judges have a more inquisitorial role and can, for example, question witnesses or seek better evidence. Judges under the English and common law systems generally are different to their continental counterparts also, inasmuch as they are all ex-trial lawyers, known here in England as barristers, rather than career judges from judge school. And they are appointed by an independent judicial body headed in England and Wales by the Lord Chancellor. As a result, judges have a great deal of experience of trial situations before they assume their roles. Also, they must be free of political influence and prepared to resist it in controversial or politically sensitive cases. To try to ensure this, judges are appointed for life and cannot be sacked or fired other than by an act of Parliament, thereby ensuring the separation of the judiciary from the executive, at least in theory. This separation is key to any properly functioning democracy and requires constant vigilance. Another puzzling feature of the English legal system for continental lawyers is the distinction between common law, i.e., judge-made law, and equity. I do not intend to go into all the complexities involved in this distinction at this stage, but to touch for now on some of the main features of it. Equity, in essence, is a system of fairness in the law, which seeks to reduce the potential harshness of the common law in certain situations. It is, therefore, a shield to protect litigants in certain defined situations. Which defined situations, you may ask? Situations defined in previous similar cases is the answer. I must stress, it is not simply what a judge thinks is just or fair in the situation. It is also not a sword to attack others, or the basis for a lawsuit known as a cause of action. In contrast to the common law, which operates in a rather mechanical way under the doctrine of precedent and according to strict rules, so, for example, situation X always gives result Y, equity is open-textured and operates according to principles, which include the following. First, and perhaps foremost, the doctrine of clean hands. What this means is that if a party seeks to invoke equity as a shield or to look for an equitable remedy, then they must be without blame in the situation, i.e., the innocent party in every sense of the term. Also, where the common law does not provide a remedy for a litigant and justice demands that there should be one, then equity will provide one. Finally, it is important to note that where there is a clash between equity and the common law, it is equity which prevails. All courts, including commercial courts, apply equity under the English legal system. So it is not merely something of historical interest and applies to both substantive